Mass layoff is the other big category of event that would require more notices. So a mass layoff could well apply even though the facility is not going to permanently close down or be closed down at all, or any operations be discontinued. Take, for example, a large factory that is going to um, reduce its production, but still continue to produce nonetheless. Here, we're again talking, for now, by default, about a 30-day period. The numbers change and they get larger. So there is a flat threshold of 250 employees suffering employment loss under state law or 500 under federal law. If you reach that threshold, and again, this excludes part-time employees, then there is a mass layoff and notices would need to be given, barring some other exceptional circumstances, some of which we will get into. If there are less than those numbers under the respective laws, then the question is, are there nonetheless at least 25 or 50 under the state and federal laws respectively? And then, if so, do the number of employees count as at least 33%, 1/3 of the active workforce? Again, all excluding part-time employees. So this is a situation where, let's say, under the New York law, you have 200 employees in a facility. You are going to let go 40 of them permanently. That is higher than 25, but you haven't closed the plant, so it's not a plant closing. You look at the mass layoff rules. Well, 40 out of 200 does not get you to the 33% threshold, so no obligation. So there is some proportionality at stake in the event of a mass layoff, but not a plant closing. Plant closing essentially assumes that it's 100% anyway. The 250 or 500 thresholds are there for situations where, well, okay, let's just say it's a really huge operation, such that 250 or 500 wouldn't qualify as a third of the workforce. That's still large enough that Congress or the New York legislature feel is appropriate to require the employer to give these notices.